Hello, I'm Gillian Black, Commissioner at the Scottish Law Commission, and this video is to tell you a little bit about our project on civil remedies for domestic abuse. And we've presented two webinars on this, and this recording is for those who were unable to join us on those webinars. I'm going to start with an overview of the Scottish Law Commission and the work that we do before telling you a little bit more about our project and our discussion paper on civil remedies for domestic abuse. So to start, the Scottish Law Commission was established by statute, the Law Commissions Act of 1965, and it's so important to emphasise that we are independent of government. So we review the law and make recommendations to modernise and simplify the law, and we submit our final report and recommendations to government for them to implement. It's also important to emphasise that consultation is at the heart of our work. It is so important to us to speak to people, solicitors, academics, judiciary, and all those affected by this particular area of law to find out what they think is wrong with the law and how it needs to be improved. And a large part of that consultation is through our discussion paper. Now, we published our discussion paper on civil remedies for domestic abuse in October, and we are seeking views in response to that discussion paper. It's so important to inform our final recommendations to government. A typical Law Commission project will start with a reference from government or a proposal from a public consultation exercise, and once we've agreed to take it on, that becomes our current law reform project, and the team will start with a preliminary investigation and carry out research into the area of law, perhaps some comparative research, and we will aim to be formulating policy. We do that in conjunction with analysis and consultation and the work of advisory groups, and many people have helped us with our advisory group and initial stakeholder discussions so far. On the basis of that research and preliminary investigation, we formulate our proposals and publish a discussion paper, and that discussion paper is at the heart of the consultation, and we use that consultation to inform the next stage, the analysis of comments and review of proposals. As we're doing the consultation, we also host a number of seminars and public meetings, and this is to replace the seminars for those who were unable to make them. When the consultation closes in January, we will conduct an analysis of those responses that have been submitted, and the eventual aim will be to submit a report to government with recommendations for reform. Our project on civil remedies for domestic abuse is looking at the current law of exclusion orders, interdict and non-harassment orders, and our discussion paper sets out the current law and problems, puts forward proposals for reform and asks questions. We're seeking your views on these proposals. The closing date is the 22nd of January 2025. Two caveats at this stage. The first is to emphasise that we're looking at the civil law and not the criminal law. So we're looking at the remedies that victims of domestic abuse can seek in the civil courts to protect themselves, quite separate from any criminal action that may also be happening. It's also important to emphasise that we are a law reform agency, and we therefore are not looking at wider issues of service provision. So we will not be making any recommendations in relation to refuges, for example, or housing, counselling, healthcare, or even legal aid. We're looking at law reform rather than service provision more generally. To give you some statistics, the most recent Police Scotland stats from 2022-23, they recorded nearly 62,000 incidents of domestic abuse, of which 81% involved a female victim and a male suspected perpetrator, 16% involved a male victim and a female suspected perpetrator, and 4% involved same-sex victims and perpetrators. Now, we know that this is an underreporting, but it shows that there is an extensive number of incidents of domestic abuse in Scotland each year. And these are largely, but not inevitably, gendered in perpetration. Alongside these stats, Police Scotland also recorded that there were 39% of those incidents included at least one crime or offence. 61% therefore constituted domestic abuse not involving criminal conduct, which really underscores how important this current project is to make sure that there are appropriate civil remedies for those where domestic abuse has not been deemed to involve criminal conduct. Statistics from the Crown Office and Procurator Fiscal Service from 23 to 24 show that in relation to charges under the Criminal Act, the Domestic Abuse Scotland Act 2018, a statutory child aggravation was recorded against 382 cases, or 21% of those charges. So it's nearly 1 in 5 cases involved a child aggravation. And a child aggravation happens under the 2018 Act where a child has been affected or involved or implicated in the abuse, perhaps where the perpetrator has carried out the abuse in front of a child or in the presence of a child, or has even used the child to further perpetrate that abuse. These statistics from the Children's Hearings Service from 2022 to 23 show that of the nearly 11,000 referrals they had that year to the Children's Hearing Service, 20% or 2,000 were on the Section 67 referral ground that the child has or is likely to have a close connection with a person who's carried out domestic abuse. So nearly 1 in 5 of the referrals to Children's Hearings were based on domestic abuse. These statistics show just how serious a problem domestic abuse is in Scotland and how many children are impacted by domestic abuse as well. I'm going to start with an overview of the current legal regime. This is a brief overview, and then I'll look at it in more detail as I talk through our discussion paper. So the current legal regime, the Bedrock Act is really the Matrimonial Homes Family Protection Scotland Act from 1981, now over 40 years old, and that applies to spouses and to cohabitants, and it provides occupancy rights for spouses and cohabitants and the right to seek an exclusion order to exclude somebody from the family house. In relation to civil partners, the Civil Partnership Act 2004 makes the same provision for civil partners. The Protection from Abuse Scotland Act 2001 allows a power of arrest to be attached to an interdict, and the Domestic Abuse Scotland Act 2011 allows an interdict to be determined as a domestic abuse interdict. And together, to seek the maximum protection, a victim is likely to need a common law interdict, together with a power of arrest under the 2001 Act, a determination of domestic abuse under the 2011 Act, and possibly an exclusion order under the 1981 Act. An alternative route to protection is through the Protection from Harassment Act 1997, whereby the victim can seek a non-harassment order. And of course, as I've mentioned, the common law is also relevant to seek an interdict preventing conduct which puts the victim in a state of fear, alarm or distress. As you can see already, the civil protection regime currently involves 5 different acts plus the common law. It's highly complex, and for victims and their solicitors to navigate, it is not the most straightforward. In fact, it's possibly easier to give a fictional example. So here we have Lucy. She's been abused by her partner. He owns the house that they live in, so she leaves the house and he won't let her return. Her possible remedies at the moment would be to seek a grant of occupancy rights for 6 months under the 1981 Act. As a cohabitant, she does not get occupancy rights automatically. Spouses and civil partners get occupancy rights automatically by virtue of their marriage or civil partnership, but cohabitants would have to seek them for up to 6 months. They can seek an extension after 6 months, but of course that involves a return to court, which can be stressful and expensive. She may then wish to seek an exclusion order to exclude her partner from the house, probably on an interim basis, because a final exclusion order can be a very time-consuming and expensive process to seek in the civil courts. She'd be likely to seek an interdict to prevent specified conduct of her partners which causes her fear, alarm and distress. And if she wants the police to be able to arrest him or detain him, she would seek a power of arrest under the 2001 Act. And if it's determined to be a domestic abuse interdict under the 2011 Act, that means that breach of that interdict is a criminal offence. Only with the power of arrest and the domestic abuse determination is it a criminal offence to breach that interdict. Otherwise, she would have to raise a special action, a separate court action for breach of interdict. So these concerns have been reiterated to us many times in the course of the last year of this project, speaking to stakeholders. Concerns include, as we've already seen, the legislation is complicated and confusing. There are multiple different protective remedies available in different statutes with different threshold tests and different terminology. Trying to navigate the system is not easy. Cohabitants, as we've seen, are treated differently to spouses and civil partners in relation to occupancy rights and powers of arrest, and I'll speak more about that in a minute. And problems with enforcing an interdict. No direct enforcement unless the victim has already sought a power of arrest and determination of domestic abuse. So an interdict needs to be supplemented by 2 different statutes to be directly enforceable by the police as a criminal offence. There's also the question as to whether remedies should be available more widely. At the moment, Scotland defines domestic abuse as abuse between partners and ex-partners. It's very much focused on intimate relationships. But other jurisdictions define it to encompass other family relationships. So, should Scotland also recognise domestic abuse between an adult child to a parent or between siblings? There is insufficient recognition of the impact of domestic abuse on children, and this comes through loud and clear from everyone we have spoken to. It's also unclear how or if the law interacts with criminal law and child law, and there is a lack of communication between the civil and the criminal courts. Alongside that, there's a lack of special measures and protection for victim survivors in civil cases, so they can be exposed to their abuser in the court building, for example, and they don't get the benefit of the special protection measures that can be put in place in criminal cases. Non-harassment orders under the 1997 Act work, but they don't address property rights. Cumulatively, there is a picture of severe concern about the applicability and availability of civil remedies in Scotland. So our discussion paper looks at how we can try to improve the law here. And as an overview of our discussion paper, we start in chapter 1 is the introductory chapter, and then chapter 2 looks at our international obligations, treaties and international human rights obligations to which we are subject, such as the European Convention on Human Rights, the UNCRC in relation to children, CEDAW and the Istanbul Convention. Now, there are no questions in chapter 2 of the discussion paper, that is set out for information only, but the remaining chapters do have questions, and we start with chapter 3 on occupancy rights. Chapter 4 sets out our existing legal framework, and together Chapter 4 and Chapter 5 form the core chapters of the discussion paper. Chapter 4 reviewing the existing law, and Chapter 5 sets out the proposal for a new law. Chapter 6 looks at the parties to domestic abuse, and Chapter 7 focuses on domestic abuse and children. Chapter 8 looks at access to justice. So chapters 3, 6, 7 and 8 all deal with specific issues and ask for responses on those points. Chapters 4 and 5 form the core of the discussion paper looking at the existing law and proposals for a new law of civil remedies. I'm going to take a few minutes to talk through each chapter in turn, starting with Chapter 3, Occupancy Rights. The 1981 Act and the Civil Partnership Act 2004 provide for occupancy rights, which is the right to live in the house, and these can be suspended through an exclusion order, which prohibits the person from entering the house. Now, occupancy rights and exclusion orders apply in all cases where the parties are married or in a civil partnership, not just where there is domestic abuse. And it's important to emphasise that our reforms would apply to all occupancy rights, not just where there is domestic abuse. So please do encourage your property law colleagues to respond to Chapter 3. Very important to us to know how these reforms would work in a property law context as well. Some of the problems with occupancy rights. As I've mentioned, cohabitants have to apply to court and a grant of occupancy rights lasts for 6 months. So they have to go through an extra hoop, jump through an extra hoop before they can seek protection by seeking a grant of occupancy rights. We ask, should cohabitants get occupancy rights automatically? Now, we are very aware that there are problems with this, and in fact, this could cause more problems than it solves, but we ask the question and we're keen to hear your views. Alternatively, if cohabitants still need to apply to court to get occupancy rights, we ask whether a court order should last for 12 months instead of 6, or a maximum of 12 months instead of 6 at the court's discretion. That would allow the victim to have a longer period of certainty before they need to return to court for renewal, and that might make a considerable difference. We also ask whether the court should be able to make an exclusion order where there's a criminal conviction for domestic abuse. So if the perpetrator is convicted of the criminal offence of domestic abuse, should the court be able to exclude the perpetrator from their house by way of an exclusion order? And we've put forward this proposal modelling it on the non-harassment order that the criminal courts can make following a criminal conviction for domestic abuse. So we think that they should be able to build on that by also making an exclusion order where appropriate. We're also interested in whether perpetrators try to sell the house or transfer the tenancy to defeat the victim's occupancy rights. So if you have any evidence of this, we're very keen to hear from you. And we're also keen to have suggestions on what could stop this, what could prevent perpetrators from selling or transferring the house to defeat the victim's occupancy rights. Moving on to Chapter 4, the existing legal framework. We put forward some fairly technical proposals to improve the law here. It remains a complex system, but we think there are some reforms which could improve it. So there's a problem in relation to exclusion orders for cohabitants because the wording at the moment is framed in the present tense, cohabitants who are cohabiting. And there has been case law in this area. Lord President Hope, in particular, in a 1994 decision called Armour against Anderson, confirmed that it does apply to cohabitants who were cohabiting at the time of abuse, but this still comes up in litigation today. And we think that tweaking the wording here could confirm on the face of the statute that exclusion orders are for cohabitants who were cohabiting at the time of abuse and not just those who are currently cohabiting. We also ask if cohabitants should be brought in line with spouses and civil partners in relation to seeking a power of arrest. At the moment, where a spouse or a civil partner has an interdict to protect them from abuse, and that is ancillary to an exclusion order, the court must attach a power of arrest. There's no discretion. If an interdict for a spouse or a civil partner is ancillary to an exclusion order, the court must attach a power of arrest. Cohabitants, however, who have an interdict, which is ancillary to an exclusion order, exactly the same protection, an interdict ancillary to an exclusion order, can only get a power of arrest if the perpetrator has been heard or been given the opportunity to be heard by court. And secondly, the victim can show that a power of arrest is necessary to protect them from abuse. And we don't think that differential treatment is justified, and we ask whether cohabitants should be brought within the main provision for spouses and civil partners in the 2001 Act in relation to powers of arrest. We're also conscious that powers of arrest, whether for spouses, civil partners or cohabitants, currently only last for a maximum of 3 years, regardless of how long the interdict is. So you could have a situation where a victim gets an interdict for 10 years to protect them, but the power of arrest which is attached falls away after 3 years. Now again, they can go back to court and ask for it to be reattached for another 3 years, but that involves stress and expense again. It risks antagonising the perpetrator further. They may also be unaware that it falls away after 3 years. And we think there'd be a lot to be said for aligning the power of arrest for the same duration as the interdict. So the court makes the power of arrest for the same duration as the interdict in domestic abuse cases. And we don't make any proposals in relation to the 1997 Act. NHOs seem to be working fairly well. In Chapter 5, we put forward a proposal for a new law, and what we propose here is a statutory delict of domestic abuse. Now, a delict is a civil wrong. It recognises harm done and it makes provision for civil remedies. There is a long history in Scots law of delict, and it's often closely allied to criminal law. So assault, for example, is a criminal offence, but it's also a delict. So as well as the criminal law taking action if assault is carried out, the victim can also seek a civil compensation or an interdict to prevent future assault. So we think that there should be a statutory delict of domestic abuse to sit alongside the criminal law treatment of domestic abuse. Having a new statute which introduces a delict of domestic abuse would allow the law to provide a specific definition of domestic abuse. There is no definition of domestic abuse in the civil sphere. Set out specific remedies targeted specifically to victims of domestic abuse. What do they need to protect them? The statute could address those very clearly and provide for supplementary orders and provisions. In defining domestic abuse, we think there would be a huge benefit to modelling it on the definition of abusive behaviour in the Domestic Abuse Scotland Act 2018. This has been well received and is well understood now by the judiciary and lawyers, and we think there'd be a lot to be said for building on that definition in the civil context. Abusive behaviour under the 2018 Act is defined as where the abuser, engages in a course of behaviour which is abusive of their partner or ex-partner, and either a reasonable person would consider that course of behaviour to cause the victim to suffer physical or psychological harm, so a reasonable person considers it's likely to, or either the perpetrator intends to cause physical or psychological harm or is reckless about causing the victim physical or psychological harm. So there is an element of objectivity here. Even if the perpetrator doesn't intend to cause harm, if a reasonable person would consider that behaviour to cause harm, then it will suffice and it will meet the definition of abusive behaviour. Helpfully, the emphasis is on physical or psychological harm, and the statute defines psychological harm to include fear, alarm and distress. Along with that definition, though, we wonder if there should be specific definitions of tech abuse, economic abuse and immigration abuse. Now, these are 3 different areas that have stood out to us in the course of our preliminary research in this project as being hugely problematic and perhaps not always recognised by the judiciary. By putting a definition of these terms in the statute, it would really bring it to the attention of everybody involved, the judiciary, solicitors, and of course, victims and abusers. The solicitors we've spoken to tell us that they have not seen a case in the last year or the last 2 years that has not involved tech abuse. And this is where technology is used to further perpetrate domestic abuse. The most obvious example might be using intimate images and threatening to put them on Facebook or social media, for example. But in fact, it's much more pervasive. You could use apps on your phone to track the victim so that you know where they are at all times, to control the central heating, for example, lock the victim in the house and use an app to turn the central heating off, use technology to monitor their spending potentially, and also to ring doorbells, for example, to control or to see who is going in and out of the house. And this means that the victim can never, ever get away from the abuse being perpetrated against him. The perpetrator can control the victim extensively through use of technology. Economic abuse is where the perpetrator controls the victim's access to resources. And it's not just financial abuse, it includes that, but it goes much wider than control of finances. So it does include financial abuse, including coerced debt, where the victim is forced to take on debt on behalf of the perpetrator. But it also includes access to resources, including food, heating, housing, clothing, access to education, access to job. If the perpetrator stops the victim from being able to work, then that is economic abuse. We know that this is perpetrated throughout the relationship, and we know that it often ramps up at the end of the relationship and thereafter, after the parties separate, using economics to control the relationship between the parties, even once they've separated. Immigration abuse is where the victim has insecure immigration status and that is weaponized against them. So the perpetrator might say, if you go to the police about this abuse, they will deport you from the country because you're not meant to be here. They might detain the victim's passport or their other identification document, making it very difficult for the victim to seek help. There can be huge cultural issues as well about approaching the police. We think that the 2018 Act probably does cover these types of abuse. We think that it's probably covered under the current criminal definition, but there would be merit in nevertheless naming them and identifying them specifically in the civil law legislation. In each case, however, the conduct would need to meet the definition of abusive behaviour. So it's not the conduct, it's not simply controlling the heating by an app, which many of us might do, which is abusive. It would have to meet the standard of abusive behaviour. If the definition of domestic abuse is met, the statute would then be able to set out appropriate remedies. And we propose a new civil remedy, a Domestic Abuse Civil Protection and Redress Order, or a DACPRO. And this would be an umbrella remedy, and there'd be a menu, a suite of individual remedies underneath, and the victim would be able to select and seek from the court the ones which are most relevant and appropriate to them. And there are 6 different remedies that we think would sit under this umbrella DACPRO. The first is a civil protection order for the victim and related parties, such as children. And this would be akin to an interdict, a common law interdict, and it would be an order to prevent and prohibit the harmful conduct, the abusive conduct. Many delicts can also be remedied by a redress order for compensation, which is a financial sum to be paid from the person who's caused the harm to the victim. And we have spoken to some solicitors who have told us that in some cases, the only thing which has finally stopped the harm is the threat of, or indeed the actual seeking financial compensation from the perpetrator, the abuser. The redress order would compensate the victim for harm that she's suffered or for loss and damage to property, for example. And we're aware that, of course, for some victims, the perpetrator may have no financial resources to meet any redress order. But we think that for perpetrators who do have financial resources to pay compensation, then a redress order could be a hugely important remedy for the victim. We also propose a civil barring order. Now, this would be similar to, but absolutely not identical to, an exclusion order, and it would bar the perpetrator from the house for a set period, a short period of time. One critical difference is that it would not rely on the parties having occupancy rights. So the perpetrator would be barred under a civil barring order, regardless of the parties' occupancy rights. We've modelled our proposals here on the Domestic Abuse Scotland Act 2021, which introduces domestic abuse protection notices and domestic abuse protection orders. Those are sought by the police on behalf of the victim. Our equivalent that we propose would be sought by the victim themselves to seek a short civil barring order. 2 other very important remedies we think are probably available under the common law but are not commonly used and people may not be aware of them. The first is an order for the return of documents. We know how damaging it can be and how distressing it can be to victims where passports, children's passports, birth certificates, wedding certificates, mortgage or lease documentation is withheld by the perpetrator. The victim should be able to go to court to get those documents that they're entitled to returned to them. This would particularly help victims of immigration abuse who would be able to seek any documents that they need to exist in this country and to be recognised by the immigration system. Alongside that, we also propose an order for the return of property which belongs to the victim. So, for example, we've heard of abusers who hold on to the victim's work laptop so the victim can't carry out work, or indeed other property. Jewellery sets, which might have been given in contemplation of marriage or as a dowry, can be withheld by the perpetrator. and their families possibly. We've also heard of abusers who hold on to children's property, whether it's a video games console or their soft toys. And of course, this can all be hugely distressing to the family and the victim and the children. We think that a specific order for the return of property under a DAC Pro would make a significant difference in these cases. The final order that we propose is an order for the care of or delivery of pets. There is clear evidence that domestic abuse often happens in the same context as abuse of pets, and we know that some victims will not leave the house and not leave the abuse because of the concern for the pet. We think that this needs to be explicitly recognised through an order which would make provision to protect the pet, or indeed to deliver it either to the victim or perhaps to a charity that would be willing to look after the pet for a short period until the victim is in a position to take care of the pet. If we apply this in the context of our fictional case of Lucy, for example, she could seek a DAC Pro which would comprise a civil protection order, which would protect her from future harm, a civil barring order to exclude the perpetrator from the house for a short period, and possibly an order for the return of the property if he's holding on to her property, or indeed an order for the care of the cat if she has one. So Lucy could build up the protection she needs from this menu, seeking a DAC Pro comprising the elements that she requires for her protection. Of course, remedies are only efficient if they can be enforced. We suggest that elements of the DAC Pro should be available ex parte without notice to the perpetrator, some elements without notice to the perpetrator, and indeed some on an interim basis, not just a final basis, but an interim basis. Critically, we propose that breach of a DAC Pro should be a criminal offence without the need to seek a separate power of arrest under the 2001 Act and without the need to seek a declaration of domestic abuse under the 2021 Act. This would not apply to any orders for redress. Orders for financial compensation wouldn't usually be, breach of those would not usually be a criminal offence, and we agree that that should continue. But breach of the other elements of a DAC Pro should be a criminal offence without the need for any further action on the part of the victim. And in fact, this is akin to a non-harassment order under the 1997 Act, where breach of that non-harassment order is automatically a criminal offence without the victim required to take any further steps. Other provisions, we think it would be necessary to recognise behaviour which is reasonable in the circumstances by way of a defence. Now, this might seem curious at first sight, but actually it is part of the 2018 Act definition of abusive behaviour. There are defences recognised there if it's reasonable in the circumstances, and the explanatory notes to the 2018 Act give examples of when this might occur. And one example might be somebody who has a serious gambling addiction and is spending the family money, which is otherwise required for housing and food. In that case, controlling that gambler, that addict's access to some financial resources is reasonable in the circumstances. That's one of the examples that they give. We also think it should be possible to extend the DAC Pro not just to the perpetrator, but to associates, those who perpetrate abuse with the encouragement or on behalf of the perpetrator. Now, we have heard of victims who have finally managed to get that interdict to stop the abuse, and the perpetrator does then stop the abuse, but it is continued by his friends or family on his behalf effectively. So we think that if a DAC Pro is granted against a perpetrator, then it should be able to be extended by the court to associates who might or who are perpetrating abuse on behalf of or with the encouragement of the perpetrator. We also wonder whether third parties, family, friends or support organisations should be able to seek a DAC Pro on behalf of a victim. And we recognise that there's very finely balanced issues here. In the first case, it's so important to recognise the autonomy of the victim, and it's very empowering for the victim to seek the DAC Pro on their own behalf. However, there can be some situations where the victim is just not able to, possibly because of the abuse itself, to seek that remedy. So we ask whether third parties should be able to seek a DAC Pro on behalf of a victim, and if so, in what circumstances. We propose that both the existing law and the new law, if it was introduced, would operate side by side, at least to start with. We hope that any new law, as we've envisaged it in Chapter 5, would be the go-to law for victims and their legal advisors. But we think that there is merit in keeping the existing system in place, at least to start with, and then in future we can review how they're working and perhaps start to repeal some of the existing structure. But that would be a question for down the line. We seek views from you on all of these elements in Chapter 5. It is so important to us to hear whether you think these work or what could be improved or what wouldn't work, whether there would be any unintended consequences. Please do look at Chapter 5 and we're very keen to hear your views. There are many questions there for you to respond to in relation to these new provisions that we suggest. In Chapter 5, we look at defining domestic abuse and the parties. And we ask who should be covered by the definition of domestic abuse. As I mentioned, in Scotland, domestic abuse is perpetrated between partners and ex-partners, while in England, for example, and a number of other jurisdictions, domestic abuse covers partners and ex-partners, but also relatives, including parents, children, grandparents, siblings, stepfamily, uncles, aunts, and cousins. So, should Scotland expand the definition? Now, we are aware that there are arguments for and against. All vulnerable parties should be protected, and we're very clear that there is never a justification for abuse, and abuse does happen within wider family relationships. Some family abuse can be gendered as well. So an adolescent son who abuses a mother, that is often gendered abuse. However, on the other hand, partner abuse has a different dynamic. There is something different about the intimacy of the abuse and the relationship between the partners in domestic abuse situations where it's partner-to-partner abuse. It is gendered and it's exacerbated by gender norms in society that impose certain gender norms on people in relationships, whether of different sex or same sex. We're also very conscious of a very practical and pragmatic concern, which is that to change the definition in the civil context would be inconsistent with the wider legal and policy framework in Scotland. It's been policy in Scotland and reflected in the law in Scotland for at least the last 20 years that domestic abuse is partner-to-partner or ex-partner abuse. So to move the civil law away from that would result in inconsistencies, and that is a very practical concern. In Chapter 7, we move on to look at domestic abuse and children. And children experience domestic abuse in a number of ways. First of all, they experience it in their household. Abuse perpetrated by one parent against the other affects children. Children are not oblivious to what is going on. They experience that abuse alongside the victim parent. They also experience it in their own peer-to-peer research, and there are some fairly alarming statistics from recent research about the number of young people who've experienced domestic abuse in their own relationships. And as the quote from Safe Lives shows there, the data suggests that the levels of highest severity abuse may be the highest for the youngest age group. Domestic abuse is also a relevant factor in child contact disputes. So in Chapter 7, we look at domestic abuse in each of these three contexts. It's worth highlighting the impact of domestic abuse on children, and this is a quote from the Domestic Abuse Commissioner. She tells us, and research shows, that children who are exposed to domestic abuse experience increased levels of fear, inhibition, anxiety, and depression compared to their peers. And the increased risk of mental and physical health problems continues into adulthood. Exposure to domestic abuse can severely impact a child's neurological development, and this can impact speech, language, and communication, and result in behavioural issues. Domestic abuse can also undermine the relationship between the child and the parent who's the victim. Victims' parenting can be controlled or undermined by the perpetrator, and of course the victim's parenting capacity and emotional availability can be eroded because of the very abuse that they are suffering. And that's from a report published by the Domestic Abuse Commissioner for England and Wales in 2023. So the problems with domestic abuse. In the first place, there's no real recognition of children as harmed in the legal system by living with domestic abuse. The legal system does not recognise that specific harm. There is a focus, and we know this from empirical research, recent empirical research, that there is a focus on contact at any cost in the courts, a pro-contact philosophy. There's also a mistaken belief that on separation, domestic abuse is in the past and it does not need to be dealt with, whereas in fact we know that domestic abuse continues post-separation for years, if not decades. Insufficient weight is given to the views of the child, despite a very clear requirement to do so under Section 11 of the Children's Scotland Act 1995. But evidence from research in the courts and with litigants shows that insufficient weight is given to the views of the child. There's also insufficient consideration given to the safety of the parent who is the victim. So we set out some solutions. The most important thing we think that we could do is to recognise children as victims of domestic abuse alongside the victim parent, and they would be adjoined victims in this situation. This would recognise the shared harm that they suffer from the abuser's conduct, and it would give them enhanced legal recognition and status in the justice system, both in relation to child protection orders and in relation to child contact. Now, it would only apply where there is a parent who is the primary victim, so an adjoined victim would be a status alongside a parent victim. And of course, children who suffer child abuse, that is still a separate thing. We're not planning to replace child abuse or recognition of child abuse and any protection measures that exist at the moment. So this would be an additional level of protection, recognising children as adjoined victims of domestic abuse. We also think that further reform to the Children's Scotland Act 1995 is required. And one thing that we propose is to make the safety of the child and the victim parent an explicit factor for the court to consider in making any decision about child contact. So it's not just the feasibility of the contact, but also whether the safety of the child and the victim parent. We also propose that the court should be required to give written reasons for a decision in relation to contact where there is a history of domestic abuse. And we've modelled this provision, our proposal here, on the forthcoming provision that will be introduced in the Children's Scotland Act 2020, whereby the court is required to give feedback to the child and reasons to the child in relation to their views that they've expressed. Well, not only in that situation, but we think that the court should also give written reasons for a Section 11 decision where there's a history of domestic abuse to ensure that the domestic abuse has been properly considered in reaching that decision. And of course, we hear this from many people that we've spoken to, more training is required for the judiciary and the legal profession, particularly in relation to any reforms that would be introduced. The final chapter is access to justice, and this is a fairly practical chapter looking at how we could enhance and facilitate the victim's engagement with the civil justice system. A key part of this chapter is special measures, so use of a supporter or a screen when in court, for example, should they be available when seeking a civil order for protection. We think there would be advantage to having remote hearings as a standard special measure. The risk of the abuser and the victim coming face to face in the court is still too high and often deters the victim from attending court. Facilitating remote hearings would address that concern. We ask whether personal conduct of cases by the abuser against the victim should be prohibited. And we ask, how can criminal proceedings be reliably communicated to the court in civil proceedings? Should the parties be required to disclose them, or should some other system be introduced insofar as technically possible? We've heard many times that the court in civil proceedings is unaware of criminal proceedings, and those need to be communicated. We also finish Chapter 8 with a section looking at rural and island communities, and we ask whether there are any legal measures, which could help victims in rural and island communities who may suffer particular harms through domestic abuse. So our discussion paper in stats, it's 234 pages, it's 99,075 words, there are 10 chapters, and there are 58 consultation questions. At this point, I can give you the good news. We are very keen to hear your views on everything that I've talked about in this presentation, but you don't need to answer all 58 questions. It's not all or nothing. If there are particular sections, whether it's in relation to children or the new definition or occupancy rights, whatever section is most relevant to you, you can focus on that chapter or the particular chapters, and there is no obligation to answer all 58 questions. The closing date for responses is the 22nd of January 2025, so perhaps if you get an hour or two over the festive period with a mince pie and a cup of tea, you could have a look at our discussion paper and give some consideration to the questions we ask there. You can find the discussion paper on our website, and the questions and the email address to submit responses to are all available on our website. Thank you very much for listening, and it's so important to us to hear what you think, what works, and what you think could be improved in our discussion paper. A final comment, it's very helpful to hear if there are proposals that we make that you agree with, as well as ones where you think that you disagree or they could be refined or improved further. We will use all this evidence to inform our final recommendations to the Scottish Government in due course. Thank you very much.